Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me today, my good friend, special guest, Russ Cook with Cook Tillman Law Group over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney, does an excellent job. You know, one of the things that, Russ, I want to touch on, we're going to talk about IRAs here in a moment and retirement accounts in general with regard to estate planning. In particular, the way the laws have changed, and this is an important area that people need to be made aware of. But before I do that, I wanted a quick tip here. When it comes to beneficiary designations, this is something that when you're doing your estate planning, and why it's important, by the way, to we believe in a team approach, all right, that you've got your financial advisor, your estate planning attorney, and of course, ideally your tax person as well, all working together to develop the best plan for you, all right, and also to make sure that they're coordinating together. And a beneficiary designation is a great example of this. If the advisor, your financial advisor, is the ones that are helping you with those. So whether that's in a retirement account, who the monies are going to be left to, whether it's on annuities, who the beneficiary is there, understanding that the beneficiary then, on a beneficiary designation rather, that goes before any will or trust would even be looked at. So if they're listed on a particular account as the beneficiary, those monies go direct to them, no probate, no control for protections. It's just, again, immediate. So this is important to understand, and how it works with your estate planning is important that your beneficiary designations are done correctly. By the way, I'm going to take a quick moment just to say, if you'd like to get some help with your own estate planning, you can call my office. That number is 615-376-5325. Now, if you want to get the complete comprehensive financial plan at no charge to you, which of course includes the estate planning piece, we can help you with that. And in that, we're going to show you, as I mentioned, your financial future. They typically work well together. In other words, doing up your financial plan leading up to doing your estate plan is just a natural progression that makes sense. And if you know what your estate's going to be worth, likely to be worth, say 10, 15, 20 years down the road or more, isn't that going to be helpful when it comes to your estate planning as well, as far as what your needs might be? That ILET, you know, as an example, Roth conversions may come into play. So again, call the office, 615-376-5325. When you call, we'll get your information, send you out a checklist of things to bring to your appointment with me. We're going to look at income. We're going to look at expenses, your monthly expenses, your lifestyle expenses, assets, liabilities. We're going to factor in for inflation, taxes, rates of return on your money, all of that, again, to show your financial future and help you make it the future you want it to be. And on the estate planning side, if you've got some documents maybe you'd like to get a second set of eyes on, we can help you with that. Russ has been very gracious about this, by the way. He will look at your documents and give us some feedback as to the pros and cons of those documents. Or if you're saying, you know I need to, it's been 20 years and the kids are all grown and things have changed and I need to redo my estate plan, Russ has also offered, normally it's to meet with Russ and for an hour's consultation is $450. Here, Russ will meet with you at no charge. If you call my office, again, we'll set that up for you to go over your estate plan and help you with that. Ideally, I'll sit down with you first and give you some basics, and then bring Russ in, and he can then answer all questions you might have and get into more advanced thing if it is important for you. All right, so again, 615-376-5325. Just call the number, and when you do come in to see me, I'll also give you a free copy of my book, 7 Steps to Financial Freedom in Retirement. All right. Tax, this is one of the areas, another change in the laws, and this has been, I'm not sure how many years ago now, Russ, but it had to do when the laws changed with regard to, and I think it was a Supreme Court decision that said retirement accounts are no longer protected. So during our lifetime, the ones that we have set up, we have both state laws and federal laws that are going to help protect our retirement accounts. And it used to be that would apply to our children, but now that's no longer the case.
Yeah, they have changed the law on that, and what that means for folks that have most of their wealth tied up in retirement accounts is you want to be very intentional of how you're going to transfer those accounts to your kids. So just to reiterate, when we set up a retirement account for ourselves, either an IRA, 401k, 403b, there are certain state and federal creditor protections that apply to that account. However, if we pass that account to our kids or to our children, then we're going to lose those protections. And so what we do as estate planners is we try to minimize the exposure that those retirement accounts might have while they're being held by the kids. So instead of them going directly to the children, we'll have them go to a trust, an irrevocable trust like the one we've been talking about that's created at death, for the benefit of the child. And again, child can be trustee, child can be beneficiary if desired. And then the language of the trust would allow us the maximum flexibility for how we need to draw money out of that retirement account so we can abide by the IRS rules and not run into any additional penalties. And so you've got a situation where normally it would not have been protected if it went directly to the child, to now it is protected because it's going into a trust for the benefit of the child.
This is one of those areas when it comes to retirement accounts in particular, there's been changes in the laws. We just talked about one, the asset protection features, but then you also have the Secure Act. So this went into effect, I believe it was 2019. No, not that long ago. It's been 2 years now, I think.
Yeah.
So 2 years ago, and what that did was it changed, so I think it was 2020. What that did was it changed the way that we deal with retirement accounts. So there was a time before this law that I could leave my IRA retirement account, and 401k, doesn't matter, whichever one, leave that to my child, and they could take minimum distributions from that over their lifetime. Well, now that's changed. We now have this new 10-year rule. And by the way, when it comes to estate planning, it's real important, too, that you understand potentially, if it's not done correctly, you could, if you had a trust as a beneficiary, you might shorten that 10-year rule to a 5-year rule, where it would have to be basically cashed out in that short a time frame. Either way, this is going to create, and of course the reason that the government did it is that's going to generate more tax revenue for them in a condensed in a shorter period of time. From a planning perspective, though, if it's been more than 2 years since you've set up your estate plan, this is an important factor for you, in particular if you've got, and as most of us do, a big chunk of what we have in our estate being our retirement accounts. In many instances, it used to be the home. Now the retirement accounts typically are the biggest asset. So how that's going to play into both tax planning as well as the asset protection features, we're trying to now balance some things that have been made more difficult. And Russ, well, we're going to take a break. Sorry. When we come back, I'm going to finish that question to Russ and let him talk a little bit about these changes and how it can affect your estate planning and some strategies that can be employed to make the most of it. First a break. Join us here. We'll be right back on a Retirement Report.